Hello, I'm Barrister Daniel Barnett, and in this video we're discussing 5 hot issues in employment law for 2021. We'll be covering the 2021 proposals to improve workers' rights, employers insisting on the coronavirus vaccine, increasing numbers of redundancies, changes following Brexit, and worker status issues. I'm joined to discuss these issues by NAOMI LING. NAOMI is a barrister specialising in employment law and pensions at Outer Temple Chambers. She has 19 years' experience representing both employers and employees in both employment tribunals and civil claims. NAOMI, the first thing you want to talk about are the current proposals to improve workers' rights. Can you run through what they are?
So there are a number of proposals that are currently being considered to strengthen employment rights. One is banning employers from making deductions from staff tips so that waiters and other staff like that would be able to keep everything they get from customers. The second is that there's a proposal from the Women and Equalities Commission of the House of Commons to extend the time within which you can bring a discrimination claim from 3 months, as it currently is, to 6 months. And the third is that you would extend protections from discrimination and redundancy for women who've been on maternity leave so that they have those protections for a period of 6 months after they come back. Women only have protections from redundancy while they're on maternity leave. And so the idea is that they would have those protections not only in that period, but when they return to work.
By protection from redundancy, are you referring to Regulation 10 of the Maternity and Parental Leave, etc. regulations, which allow women on maternity leave to trump other redundant employees when it comes to being offered suitable alternative employment?
Yes, the protection that women currently have is that if there is a redundancy situation at work and for some reason they're selected for redundancy, if there is a suitable alternative opportunity elsewhere in the employer or an associated business of the employer, the woman who's on maternity leave is entitled to be given priority for that job.
So at the moment, the right just applies to women currently on maternity leave. Who's the government proposing it be extended to cover?
So the right to be given priority in being offered suitable alternative employment is being extended to women who are pregnant and also to women who've returned from maternity leave in the last 6 months.
Do you think the proposal, if enacted, will make a lot of difference in the real world?
I must say that I am sceptical as to how meaningful this right is in practice. I have yet to see a woman who has been made redundant whilst on maternity leave, whose company has actually secured an alternative vacancy for her. In any event, there is a duty to seek suitable alternative employment for anyone whose job is made redundant. And in practice, employers want to redeploy the most suitable person into an alternative role. So the question for the employer and the employee is usually, well, is the woman who has this protection, is she suitable for the alternative role? And there's a pretty wide discretion on an employer to decide that no, she isn't.
So we've considered the proposals to stop employers making deductions from staff tips, the proposal to extend the limitation period for sex discrimination claims, and the rules relating to women who are pregnant or have returned from maternity leave, trumping those when it comes to suitable alternative employment in a redundancy situation. What other proposals is the government thinking about at the moment?
The government actually has a raft of other proposals that it's currently consulting on. The first is to abolish non-compete clauses in contracts that prevent employees going to work for competitors in the period after resigning from their job. These non-compete clauses are in a variety of contracts, for example, hairdressers, estate agents, typically for a period of 3 to 6 months. The government feels that the judiciary is becoming overactive in the way it's applying the Human Rights Act and intruding unduly into questions of policy. So it's looking at whether there needs to be a redefinition of the way that works. There's another interesting consultation on the law relating to freedom of expression and whether employees have any obligations to their employers when they're expressing their views on social media. Conversely, whether employers have any right to dismiss or discipline employees who are expressing views they don't like on social media. Then there's another consultation on whether to extend sick pay to workers who earn below the lower earnings limit, which is currently £118 a week. And finally, there's a consultation on whether to give workers a right to receive notice of work shifts and compensation if there's a late shift cancellation. And that's really significant at the moment because of the increasing number of workers who are on 0 hours contracts with insecure employment because their employers aren't obliged to provide them with a set amount of work and therefore set wages each week.
I think the biggest issue of the year is going to be those employers who decide they want their employees to have the coronavirus vaccine and have to carry out that very difficult balancing act between the rights of an individual to refuse the vaccine and the right of the employer to protect fellow workers, protect people the worker comes into contact with, and of course just impose standards on the business. And that's going to be a very difficult balancing act. We've heard recently about a firm of plumbers who have said that as soon as the vaccine is widely available, then they're going to refuse to hire any new plumbers who haven't had the coronavirus vaccine. NAOMI LING, do you think there are any circumstances where an employer can say either have the vaccine or we're going to dismiss you?
Yes, if you're the NHS or if you run a care home and you're caring for vulnerable people, that would be an obvious good reason for requiring your employees to have the vaccine, because you have a duty to safeguard the health of the people you care for. But I think even there, the question of whether you can require employees to have the vaccine is a vexed one. And that's because at present, there's no evidence that the vaccine actually prevents you from transmitting the virus to other people. So if it would make no difference to whether you actually gave the virus to people within your care, your employer would find it more difficult to say it's compulsory for you to have the vaccine and to remain in employment. I should say, though, that they are expecting to gather more evidence in the coming months as to whether or not the vaccine will prevent transmission, and so the picture will evolve.
My understanding of the medical position, largely from listening to Professor Van Tam at the Downing Street briefings, is that although there's no absolute figures or certainty that it prevents transmission, there's considerable medical consensus that the coronavirus vaccine impedes or reduces transmission between people of the virus. To what extent do you think an employer is entitled to say, well, even if it will only save one person in a care home from getting coronavirus, but not 20 or 50, even if it will only save one person, that's enough of a reason for us to insist you have the vaccine?
I think it might well do, if I'm honest, but I really think that it is a question of actually looking at what the medical evidence is at the time that you put that policy in place and at the time at which you dismiss the employee.
I just mentioned a moment ago the plumbing company that's going to be telling new recruits that they can't come and join it unless they've had the vaccine. Do you have a view on the legality of that?
Again, I think it really does depend on the facts of each case. I suppose that if this company was able to show that it simply couldn't sell its services to people looking for plumbers, if it couldn't offer plumbers who'd had the vaccine, it might be able to justify a policy like that. But I have to say that I think that that would be surprising if that were the case. I think that in practice it is unlikely that employers will be putting that kind of policy in place.
Okay, thank you, NAOMI. And just turning from talking to you, NAOMI, I have recorded a very detailed video on what you can do if your employer insists on you having the vaccine. And can you be dismissed, or do you have a right to remain in your job? And you can see that video up here. And on that note, I'm going to turn to the next topic, which is redundancy. At the time of recording this in January 2021, it's just been reported that the UK unemployment rate has hit 5% for the first time in many years. NAOMI LING, why is redundancy such a hot topic at the moment?
Well, it's a hot issue because, of course, businesses are struggling because of COVID, and they're also struggling because of Brexit, particularly employers that are seeking to export to the EU. I think what both employees and employers need to be aware of is that a redundancy situation does arise if there's a need for fewer people to do the work. So if a shop is taking less money and needs to reduce its staff, that will be a redundancy situation. If a site closes down because an employer needs to shut its warehouse in the UK and open one up in the Netherlands, that will be a redundancy situation. And if an employer goes out of business completely, that will be a redundancy situation. And employees may disagree with the reasons that the employer has for making these business decisions, but in practice it's rare to be able to challenge them.
I want to deal with this from the point of view of employees, but just before I ask you to carry on, NAOMI, I'm talking to employers now. I've put together a fabulous resource for any employers who are thinking of making redundancies and need some help with the process, need some help, some guidance, and need to know how to do it properly. It's called Getting Redundancy Right, www.gettingredundancyright.com. It's a 10-part course and there's a link to it in the notes below, but as well as the 10 video modules that I've recorded explaining how redundancy processes work and exactly step by step what you need to do, there's a number of other resources there as well. And they include my model redundancy selection matrix, my redundancy policy prepared specifically for small and medium businesses, access to a private online forum for discussing redundancy issues, transcripts of all 10 video modules, template redundancy letters for you to use when writing to employees, and a bonus course I've recorded on changing terms and conditions of employment. If you're interested in having a look, it's designed specifically for small and medium employers, and you can get more information about it using the link below, www.gettingredundancyright.com. And NAOMI Ling, back to you. I want to deal with two things: solvent employers and insolvent employers. You've said it's difficult to challenge a redundancy process. Is it possible, if you're an employee, to say to your employer, I want to challenge the fact that you've chosen me for redundancy and you haven't chosen the person sitting next to me at the next desk?
Yes, if you have 2 years of employment, then you will have unfair dismissal rights, and your employer needs to employ a fair process in selecting you for dismissal. So there are various ways in which the employer can go about doing that. It can either delete particular posts from its structure and dismiss the people in those posts. It can create a pool for selection, in which case it needs to have an objective selection criteria and process for the employees in that pool. Or it can delete its whole staffing structure and require all staff to apply for new jobs in the new structure. But either way, it needs to consult properly with its employees, which means asking them what it thinks about its proposals while they're still at a formative stage and listening to what they say. It needs to be objective about how it makes its selection and apply a fair process. And it must also always consider whether it can offer employees at risk of redundancy any suitable alternative employment.
So if I'm upset about being selected for redundancy, how do I go about challenging my employer's decision?
Well, you can bring a claim to an employment tribunal, and the basis on which you can complain is you can say, my employer hasn't consulted with me adequately at the point at which the proposals to make redundancies were still at a formative stage. Or you can say, my employer didn't create the correct pool for selection. My employer didn't use the correct selection criteria. They weren't objective, or they didn't match the right considerations for our business. And my employer didn't consult with me properly in the way it applied the selection criteria. Or my employer didn't properly consider whether to offer me any other suitable employment that was available. And I must say that in my experience, Daniel, that last one is actually the one that most often is successful in tribunal.
Let's turn then to the insolvent employer. If my employer goes into liquidation or stops trading and I'm entitled to a redundancy payment or notice pay, but they haven't got the money to pay me, what can I do about it?
You would still bring a claim to the employment tribunal, but instead of the respondent being, rather your employer being liable for any redundancy payment, the government's National Insolvency Service would step in and meet the claim for a redundancy payment.
One of the big upheavals in our life is Brexit, and just before I turn to talk about the possible changes coming from Brexit, I'd like to ask you again, turning away from NAOMI, can I ask you please, if you like this video and are finding it useful, please do click the like button below. I'm just going to give you a few seconds to do that, if you don't mind me asking. 4, 3, 2, 1... Thank you. And the reason I ask you to click the like button, and if you haven't done it, do it, is that it just drives this video up the YouTube algorithm and means that it'll come to more people's attention. No one knows you've clicked the like button apart from YouTube. I don't even know. I don't see the names. But please do click it just down there. There. Thank you. Now that we've left the European Union, what laws does the UK have the freedom to change? What workers' rights does the UK have the freedom to remove that it didn't previously have while we were members of the EU?
Well, that's a very good question, because in the middle of January, the government announced a task force to look at that very issue. Which laws would we wish to change now that we can? Then towards the end of January, Kwasi Kwarteng, the business secretary, actually said that that was now not going to happen. So at the time we're recording this, it really is anyone's guess as to what approach the government is going to take to this question.
What do you think are the most likely areas for the government to legislate on now that we've left the EU and we're no longer bound by decisions of the Court of Justice of the European Union?
I think that where everyone thought the government might move would be on things like the working time regulations and also the national minimum wage regulations. So first of all, with the working time regulations, there was speculation that they would remove the 48-hour maximum working week, change the rules about breaks at work, and also get rid of the current requirement for businesses to log information about daily working hours.
Any other areas?
My feeling is that they might make changes where there have been nasty surprises for the government from the courts recently. So, for example, there's been a ruling on pension rights that says that you need to backdate all qualities back to the beginning of employment. So if you're a part-time worker, or if you were a gay person who got married and were claiming survivors' rights. The courts have said that those rights are effectively operative from the day you started employment, despite the fact that your entitlement not to be discriminated only came into force in 2006. So I think that kind of area where there's been a recent change that upsets arrangements may be the sort of area where the government says, actually, we're going to go back to the way we thought it was all along.
What about discrimination law? A few years ago, NAOMI LING, there was talk about capping discrimination awards at the same level as unfair dismissal awards, so the lower of what is now about £90,000 or a year's pay. Do you think now we've left Europe, there's likely to be any revisiting of caps to discrimination awards?
That may be an area that the government is interested in. It's not an area that I've heard there being any particular discussion of lately. In practice, there aren't that many really large discrimination awards. There are large payments that are made where you have large multiples of people all claiming a small amount. That wouldn't be affected by the kind of change you just mentioned.
How about TUPE? It's Europe-based, but it's pretty much part and parcel of the way we do things here now. Do you think there's going to be any changes to, for example, TUPE information and consultation?
Well, the interesting thing about TUPE laws is that they are an area where the government has historically gold-plated our European obligations. One area that I think the government may wish to make clearer is where there are pension entitlements that transfer, because that area is currently very uncertain. And so that might be the sort of thing where the government says, let's just be really clear about the way TUPE works with our domestic arrangements for pension rights.
Anything else?
Currently, there is a rule under TUPE that says that you can't actually vary your employment rights after a transfer if the reason for the variation is the transfer. And of course, often the reason for the variation is the transfer because the employer wants to harmonise terms and conditions between different employees. That might be an area in which the government takes an interest in simplifying the law so that employers can make sure that there's no unfairness as between different groups of employees that it employs.
Thank you. And if you're interested in finding out more about the way that UK law might change now that we've Brexited, I did actually record a video on this, or I did a long talk on this in 2019, and I've clipped the highlights, an 8-minute clip from that talk, and I'm linking to it up there that you can have a look at if you want. There's also a link in the show notes below if you want to wait till the end of this video to have a look at it. Whether we're talking about massive organisations like Uber and Deliveroo, or much smaller organisations like the National Gallery and people who take visitors on tours around the National Gallery, worker status and the gig economy was a massive issue last year, and it has been for a few years before now. Why is it continuing to be a big issue in 2021, NAOMI LING?
I think two reasons. The first is that we are waiting the outcome of an appeal to the Supreme Court by Uber against decisions of the lower court that their drivers are workers. And the second thing is that I think that more and more groups, citizens' advocacy groups, will be saying to the government, you really need to look at this and to bring forward proposals for how to protect workers in the gig economy.
Would you mind just explaining the issues in the Uber case?
There was a dispute as to whether Uber drivers were workers or not, and the Employment Tribunal, the Employment Appeal Tribunal and the Court of Appeal all decided that they were. The arguments were that there was no contract between the driver and Uber, only the driver and the passenger. Uber argued that it was solely an intermediary as between those two people. It also argued that it didn't have sufficient control over drivers to be their employer, such as to give them worker status. But the courts have found that all of those arguments had a real air of unreality to them. In practice, Uber does exert a significant degree of control over its drivers. For example, it says, well, if you haven't accepted 3 rides within 10 minutes, you're going to be signed out of the app. There are disciplinary procedures that it applies to its drivers. They are obliged to drive a certain sort of car. And so all of these indicators point towards there being a worker relationship. And so that is really what the arguments are focused on before the Supreme Court.
And what's the significance if someone is found to be a worker as opposed to being genuinely self-employed?
Well, a worker has significantly more rights. A worker has the right to the national minimum wage, to holiday pay, to protection if he or she blows the whistle. And all of those rights would not only be costly for Uber to implement, they would also be very cumbersome for Uber to implement on its current platform. And so for all those reasons, Uber is very keen to maintain its position that its drivers are self-employed rather than workers.
Thank you to NAOMI LING of Outer Temple Chambers. You can find more information about her in the notes below. Thank you to you for watching. If you found this video useful, please do like it. You can find a lot more explainers on employment law just here. This is a video that I think you'll like, and you can subscribe to my channel just down here. I've also got explainers on other areas of law such as family and crime, and you can see all my other hot topics for 2021 videos just here. Thank you for watching. Bye bye.